Good morning, everybody.
Morning.
Yes, sir.
Morning.
Yes. Yes.
Listen, this matter I'm playing for 3 weeks.
3 weeks. Mr. Chitresh, you will be appearing for.
Since the state is involved, Mr. Ashok Kumar Yadav is unable to appear. I'll be filing my Vakaratnama in this matter.
Mr. Chitresh. Undertakes to file Vakaratnama on behalf of the petitioner, same. Other side, who will appear?
I am for the state election.
AG2.
AC2 AG2 appears for the state open appearance. Let the name of AG2 appear in the cause list. And for previous council. अच्छा अच्छा ओ
Civil review number 118 of 2009, Mr. Abhay Kumar, for the petitioner, Mr. Rao.
May I seek 4 weeks time to remove the defects, Lords?
Let it be placed before a bench of which one of us, Deepak Roshanji in bracket, is not a member. Appearance record for the same order in ID also.
In the next case, grateful, Lords. Obliged.
Appeal number, item 4, appeal number 192 of 2019, Mrs. Nita Krishna, for the appellant.
Your Lordship, I pray for 2 week time to replace the defect, Your Lordship.
This is the same matter or some other matter?
No, sir, that is the same matter, Your Lordship. This time they have again pointed out the defect related to this limitation, Your Lordship. Earlier it was not pointed out.
Because you have filed the decree later on.
Yes, Your Lordship, because cage column was not there in that order, Your Lordship. When we finally filed it, then they have. Yes, Your Lordship.
Counsel for the appellant, Mr. Krishna Kumar, says for is allowed 2 weeks.
Yes, Your Lordship, I'll file it.
2 weeks.
Obliged, Your Lordship.
Office to place the file. You seem to be learning only in the defective. This defective matter will make you learn all the tricks of how to remove defect.
Yes, Your Lordship, I am doing that. I am doing from that level only, Your Lordship, and I am also arguing in few cases, Your Lordship. But unfortunately, I have not yet argued before you, Your Lordship. For the last.
No, this was in a different sense that the first training for a counsel is to remove the defects and visit this, learn the procedure, visit the stamp reporter's office. They actually instruct you how and where to remove the defect. I have learned a lot. There was a employee, he retired as section officer. Yeah. नहीं वो जो पटना से जो आए थे चंद्रमौलेश्वर. So he was in Patna also. I remember in the downstairs there was the office of stamp reporter and he was the section officer. So he used to instruct me.
Yes, Your Lordship. In this COVID period also, Your Lordship, since I reside in that area, so all the cases which were there for the defect, fortunately I have removed from the office. I was assigned this job also, that I am on the way to my home also, Your Lordship. So entire file of the office I have removed the defect, Your Lordship.
Good. For a successful lawyer, you need to learn how the advocate clerk works. Sometimes you need to work as an advocate clerk also. the affidavit and submit. Very good. Yes, next.
Item 5, WCP number 3036 of 2021, Untitled for the prisoner.
Your Lordship, by way of last indulgence, Your Lordship, I was praying for 2 weeks' time in this case to remove the defects, Your Lordship.
There's only one defect that also you couldn't remove.
I'm sorry, my Lord, it's purely my mistake, Your Lordship. I'll remove it within a week, my Lord. By way
2
of
weeks
last.
time of last indulgence.
Obliged, my Lord. Deeply obliged.
Mr. Varanja Yuria.
Orders, item 6, first appeal number 319 of 2017, Mr. Ashok Kumar Mukherjee for the appeal, Mr. Prem Nandan Rajat for the response.
Yes.
My lord, item number 6, my lord.
Yes, we are going through your supplementary affidavit.
My lord. In this matter, respondent has filed 2 supplementary affidavit, one showing his income and
And
bank statement, and another showing the admission of their child in school.
very well. Anyone appearing for the petition appellant? So we will record your undertaking, Mr. Dubey, as stated in the supplementary affidavit by the respondent.
Yes.
And this undertaking will bind the respondent to ensure that he takes care of the expenses of the child.
My lord. Probably the respondent is also appearing in the court through video conferencing.
We ask him to. Yes, he might. Mr. Akshay Mato,
My lord,
we have gone through the supplementary affidavit of the respondent and the
yes,
statements relating to the undertaking
please.
by the respondent to ensure support to all his 3 children till graduation and even thereafter. That we will record in the today's order.
My lord.
And then this matter will be posted for hearing. At least the children's interest.
Your Lordship, item number 5.
5, already time has granted to remove defects. For appearing for the respondent.
Your Lordship, I am appealing for the respondent in item number 5, Your Lordship.
Appearance. Thank your appearance.
Yes, Your Lordship. I'll send it.
इसमें लिखिए Mr. Akshay Kumar Mato for appellant, Mr. for respondent. counts of the previous orders, including the order dated 6 January 2022. Affidavits have been filed by the respondent. 2 affidavits have been filed by the respondent. The material part of the affidavit containing his undertaking about the education. Mute kariye, Mr. Mathur. About his undertaking to bear the expenses of his 3 children born out of the wedlock with the appellant are being क्या सेंटेंस शुरू हुआ ब्रेक हो जाता है
Part of the affidavit containing his undertaking to bear the expenses of 3 children born out of wedlock
with the appellant are being reproduced here in below. ये फर्स्ट एफिडेविट 6 जनवरी का पैरा 3, पैरा 4, पैरा 5 कोट करने के बाद लिखिए the appellant, a respondent has also enclosed the ITR for the years for the last 3 financial years 2019-20, 2021 and 21-22. Stop. He has also annexed the statement of bank account of bearing number so and so of IDBI Bank, पैरा 7 में लिखा हुआ है। Pension वाला promotion के लिए fabrication the above exercise, it seems that the above undertaking would ensure that the interest of that the educational needs of the 3 children born out of the wedlock between the parties are safeguarded. Stop. Since the matter has already been admitted for hearing, admit हो चुका है ना? Admitted for hearing on so and so date, let the case appear under the heading for hearing as per its age. LCR आ गया है, very well.
माइलर बच्चे के लिए कुछ खर्चा 3 बच्चा है, मुझे कोई इनकम सोर्स ऑफ इनकम नहीं है।
वो तो एंडलेस है, आप उनके घर में रह रहे हैं, वो बच्चे को पढ़ा रहे हैं, बच्चे की पढ़ाई के लिए सेम हाउस में रह रहे हैं, इसको भी रखती है और बाकी हियरिंग के टाइम में देखा जाएगा।
ऑफलाइन में
प्रेजेंस ऑफ द रेस्पोंडेंट इज डिस्पेंस्ड विद।
Item 7, civil review number 89 of 2018, Mr. Bhaiya Vishwajit Kumar for the petition.
In this case, my lord, I am appearing on behalf of the petitioner applicant, my lord.
Yes.
I come under the heading for orders, my lord. I have not gone through the office note.
No such person resides at this address. This is the service report.
So the address he has given the petition, my lord, that I have mentioned in my application, my lord.
He may not be residing. She may not be residing there.
So the address, one address is I have, my lord, of Ranchi, and another is that of Singapore.
Oh, अच्छा।
And in the address, I have taken steps for service of this, my lord.
है क्या बोल रहे हैं मिस्टर कुमार?
My lord, the address I have given in my application, my lord, is one that of Ranchi, and another is of Singapore, and I have taken steps for service of notice on both the addresses, my lord.
against me. Any case pending between the parties now?
No, no case is pending now, my lord.
We are passing it over for the day. You come out with proper instruction as to how you are going to ensure service of notice. In a
Yes.
foreign country, टू वीक्स के लिए एडजर्न कर देते हैं मिस्टर कुमार. आप प्रॉपर प्रिपरेशन करके और फिर एक दो दिन पहले नोट्स भी भेज दीजिए. What is the legal position? How will you ensure service of notice? At Singapore. Adjourn for 2 weeks in view of the office note.
Item number 8, CMP number 96 of 2018, Mr. Mohammed A. Khan for the appeal.
2 weeks time for filing. 2 weeks time required, my lord, for filing the fresh Wakalatnama is the concern where Mr. Ahmed Khan is already passed away, my lord.
2 weeks time. And let's wait for Mr.
My lord, one thing I want to say, my lord, there is CMP, my lord, and this CMP is filed for restoration of the FA number, my lord, 19517. I have to file 2 Wakalatnama, my lord, one for CMP and one for FA, my lord. Only one Wakalatnama I have to.
May you get 2 Wakalatnamas, but initially you will have to file in CMP. If the CMP is allowed, then you file separate Wakalatnama.
Obliged, my lord.
To Mohammed Anish Khan filing it.
Item number 9.
In this case, Lordship may permit me to withdraw this application on instruction that Lordship, this case may be withdrawn. Actually, Lordship, that opposite party have no trace, therefore no present address is been.
Learned counsel for the applicant, Mr. Dilip Kumar Chakravarti, seeks permission to withdraw this appeal on instructions. Formally, the appeal was directed against the judgment and decree dated 20th April 2018, passed by Learned Principal Judge, Family Court, Parkpur, in divorce suit number 14 of 2016, referred by the appellant petitioner for resolution of marriage under section 13 of the Hindu Marriage Act 1955. As being agreed by the dismissed courts.
Obliged, Your Lordship.
For admission, item number 10, WPS number 531 of 2018, Mr. Sachin Kumar for the petitioner. Mr. Rina Mukherjee for the
Praying for passover for few cases, Your Lordship. Sachin Kumar is arguing in another court, Your Lord.
Anyone for the opposite party, respondents? Mrs. Paul is there. Any passover?
Deepak Kumar Dubey will argue, Your Lordship.
Very well. Passover. All of you are ready? Mrs. Paul, Mr. Rahman,
I'm appearing on behalf of
UPSC.
respondent number 5, my lord.
Very well. Let's see.
In this case, I have filed already the counter, your
Yes, fast over, fast.
as directed by my lord, your
Pass over, pass over.
Case number 2265 of Parliament. The remarks of the listening
Nobody is appearing.
Serial 11, Your Lordship. Serial 11 कटक बेंच का ऑर्डर है, Your Lordship. Serial 11.
Katak bench. And how they have filed it here? This will be more.
Yes, I filed an application for deleting the name of the respondent number 1 who is reported to have died. There are other years are on the body.
Mrs. Pal, are you appearing? Unmute yourself. नहीं हुआ, unmute नहीं हुआ अभी. बड़ा मुश्किल है. Not able to hear. यहीं से unmute करते हैं. होगा. Mrs. Paul, your voice is not reaching us. It's muted perhaps. You need some junior to assist you in operating the system. Not able to hear. Oh. Yes, Mr. Gautam Rakesh?
Yes, Your Lordship. This
how is this repetition, how is it maintainable here?
Yes, Your Lordship. This is our preliminary objection. That the impugned order has been passed by the learned Katak bench of CAT.
How it could be filed by the office of Mrs. Paul?
शिक्षा में डिस्कस किया तो फिर यहाँ पर पूरा कोर्ट का लास्ट में none of the provision of the procedure has been fulfilled in everything. So as we have to entertain hence without going into merit of this story is dismissed on point of jurisdiction. It should have been point of way.
Yes, my lord.
Yes, Mrs. Paul.
Yes, my lord. In this case, my submission is that, my lord, though it has been passed by the court of bench, but the bench has no jurisdiction to pass that order. That's why he is dismissed. He is now residing at Ranchi, and all the respondents are under the Jharkhand CAT, my lord. But it has been passed by the
This
Odisha
order,
CAT.
Mr. Paul, this order of Cuttack bench can be challenged before the jurisdictional high
Before
court.
the
That was-
court of yes, yes, my lord. To be in view of that, my lord.
और नहीं तो आप यहाँ ओए फाइल करिए, क्यों नहीं हो यहाँ ओए फाइल कर सकते?
No, with that liberty may be given to me because it was my suggestion. If it is beyond the jurisdiction, then you may file the case before the CAT. Yeah.
The petitioner approached this court with the following prayers. Para 1, A, B, C, D. Stop. अच्छा, ये 2009 का हो रहा है, 2015, 18 का ये चैलेंज है।
Main ground of my lord that
The impugned order has been passed by the Cuttack bench
yes
of the Learned Central Administrative Tribunal. Stop. In view of the ratio rendered by the apex court in the Constitution bench judgment in the case of L. Chandrakumar versus so and so, 1998. Check कर लीजिएगा citation. The
78 years Supreme Court 84.
98.
1997 volume such and such page Supreme Court 84. That is the last. Let it be verified. Let it be verified. That will be verified.
The writ petition, the present writ petition is not maintainable before this court. Stop. Such an order is subject to challenge before the jurisdictional high court. Stop. As has also been recently held in the case of so and so.
That is the Chief Secretary of West Bengal. Recently that did it.
The counsel for the, you know all that.
My lord, kindly consider when I filed that case, my lord, that was my suggestion. You file it before the CAT, but unless and until order is passed, my lord, he can move ahead. That's why I.
The counsel for the petitioner, Mrs. M. Paul, however, seeks permission to withdraw this writ application in order to move before the appropriate forum/court. Writ petition is dismissed as withdrawn.
Appropriate forum / my lord tribunal लिखा जाए.
Tribunal
yes.
/ court.
Yes. Much obliged.
Mr. Gautam Rakesh takes a preliminary objection to the maintenance.
Item 12, WPS number 5369 of
My lord, I am appearing.
Please, my lord.
I am preparing for railway in this case. Mr. P.C. Sinha is ill, my lord. I think he has not joined also. I will be assisting your lordship on behalf of railway.
Yes.
Yeah, my lord will take into account the counter affidavit filed, supplementary counter affidavit filed on 28/1/22.
I'll be confining to two paragraphs specifically, my lord. That is relevant is paragraph 11. Yes, my lord. It is
Just
submitted, my lord. The most important factor is, my lord, to be taken judicial notice is fourth line from the top, paragraph 11. May I read it, my lord?
just a minute.
हो गया हो गया हो गया कितने बार
This last supplementary counter affidavit
Yes,
filed
yes,
by the
yes, yes, my lord. Last
Mr.
supplementary contract affidavit
Mr.
filed on 28th January 22.
Please wait. Hear what we
Paragraph.
are saying. The last supplementary counter affidavit of respondent number 1 to 3, which has been filed on 28th January 2022, Mr. Modi.
Yes, yes, my lord.
Yes, yes.
That I was relying upon. Paragraph 11.
मिस्टर प्रसाद, आप पूरी हम लोग की बात सुनिए. लास्ट डेट को भी आप लोग दोनों आपस में बहुत लड़ने लगे थे. We had to make comments upon it.
ठीक है, सॉरी.
Some questions to Mr. Modi.
Yes, my lord.
अच्छा, ठीक है.
इसमें आपने उनको रेस्पोंडेंट प्राइवेट रेस्पोंडेंट को 2 बार जो 30% अलाउंस मिला उसके बारे में तो जवाब नहीं दिया.
हम समझा देते हैं हुजूर को. हमने रूल लगाया है जिसके तहत 1196 में जो 6 पे कमिटी आया है उसका कैसे पे फिक्सेशन हुआ. पे फिक्सेशन हमने दिया है हुजूर. पेज 5 में आया जाए सप्लीमेंट्री काउंटर एफिडेविट का.
वो 96 के बाद जो आया वो हम समझ रहे हैं, लेकिन फिर पहली बार जो मिला उसका आपने कोई जिक्र नहीं किया.
हाँ, वो ये 6 पे इनका ग्रीवांस ये है कि जब 6 पे कमीशन का हमने पे फिक्सेशन किया तब भी इनको 30% हमने दिया और जब इनका प्रमोशन हुआ तब भी हमने 30% दिया. 2 बार इनको 30% दिया. दैट इज हिज ग्रीवांस. नाउ आई विल एक्सप्लेन.
पहली बार कब मिला 30%?
इनको पहली बार जब इनका पे फिक्सेशन हुआ 5th पे कमीशन में इन द स्केल ऑफ 4500 to 7000 उस वक्त इनको 30% दिया गया और हम उसका रूल है ये रिस्पोंडेंट्स को, रिस्पोंडेंट नंबर 4 को. इसका रूल देखा जाएगा हुजूर. हमने रूल सी लगाया है, ये एनेक्चर सी लगाया है. एनेक्चर सी के पहले हम एनेक्चर बी प्रेस करना चाहेंगे जिसमें 924 जो कोटेड है हुजूर, जिसमें कि इनको मिलता है ये बेनिफिट ऑफ 30%. इसका पेज 16 देखा जाएगा सप्लीमेंट्री काउंटर एफिडेविट का. एनेक्चर बी 924
924
reckoning of running allowance as pay. 30%. Your Honor has got it. My Lord has got it. Page 16.
16, yes.
924. Reckoning of running allowance as pay. Left hand column में नीचे में हूँ. 30% of basic pay of running staff shall be ये हम पढ़ नहीं पा रहे हैं. As the pay for the following purpose. इनमें D देखा जाएगा. Fixation of pay in stationary post. When they are promoted or they are in their pay is to be fixed in stationary post, then they are to be given 30% benefit of 30% allowance. And then I देखा जाएगा next में dearness while calculating dearness allowance, additional dearness allowance. Then also 30% basic pay should be taken as of the running staff should be taken into consideration. Now your Honor will come, my Lord will come to next page, Annexure C. This is the rule, pay fixation rule fixed by the railway after coming into force of the 5th Pay Commission recommendation. In exercise of power conferred by the proviso to Article 309 of the Constitution, the petitioner the President hereby makes the following rules, namely, these rules may be called Railway Service Revised Pay Rule 1997. Then two, category of railway servant to whom the rule apply. 1. Save as otherwise provided by or under these rules. These rules shall apply to persons appointed to the railway service. So all railway employees will be governed by this rule. Then 3. Basic pay. 1. Basic pay means pay drawn in the prescribed scale of any pay, including stagnation, increment, but does not include any other type of pay like special pay, personal pay. Now, my Lord will come to page 20. That is the fixation, how the pay is to be fixed. Page 20, Rule 7. Fixation of initial pay in the revised scale. A. In the case of all employees, an amount representing 40% of the basic pay in the existing scale shall be added to the existing emolument of the employee. My Lord may note it. I will show how it has been done. 40% of the basic pay is to be added. Then next page, B. Next page, my Lord will come, page 21, B.
Yes.
In case of employees who are in receipt of special pay allowance in addition to pay in the existing pay scale, like the respondent number 4, 30% running allowance, which has been recommended for replacement by a scale of pay without any special pay allowance, pay shall be fixed in the revised scale in accordance with the provision of clause A above, except that in such cases existing allowance shall include the basic pay in the existing scale जो कि special pay को नहीं include करेगा, then existing amount of special allowance, now that is to be included. Then admissible dearness allowance, index average so and so we are not concerned, जो भी है 148% housework, and the amount of first and second installment, ये भी important है, the amount of first and second installment of interim relief as admissible on the basic pay in the existing scale and special pay under the relevant order. So two ennominations has to be given, second ennomination and special ennomination. Now my Lord will come to page 5. This is how under these rules the pay has been fixed after coming into force of this 5th Pay Commission of the respondent number 4. Page 5, top. Basic pay as on 1196 in fourth pay commission 1470 in the scale of 1200 to 2040. He was drawing basic pay of rupees 1470. 48% of the basic 1470 is the basic pay plus 30% basic pay added 441, that comes to 1911, and 148% of 1911 is 2828. This is what has been added. Now, first interim relief 100 rupees. Then 10%, second interim relief 10% of pay plus running allowance. 1991, 10% is 191. Then 40% of basic pay 588. Total comes to 5177 and his pay was fixed at 5250. So this has been done in accordance with the rules by giving him benefit of 30% running allowance. The rules also say special pay is to be added. Basic pay without special pay, and then it has to be added. And I have read from Rule 924 that while calculating DNL ROS, running pay is to be taken into consideration. So his pay has been fixed at rupees 5250 in accordance with the rules. In accordance with law. Second time now I have read it. Now I have read. Now let us come back to 16, page 16. The fixation of pay in stationary post. When he was promoted to as section controller. Section controller is a post in stationary. Is a stationary post. Now, as per Rule 924,
Yes.
he has to be given 30% running allowance. That is what has been done. Now, Your Honor, my Lord will come to page 6, para 11, to which my learned friend is making grievance. Let me read the entire paragraph.
Yes.
That it is humbly stated and submitted that Mr. D.K. Mishra was selected and promoted on the post of section controller in control cadre under promotional quota with effect from 26 to 1997 in the pay scale of rupees 5500, 175, 9000. Therefore, his pay was fixed with benefit of 30% allowance with effect from 26 to 97 in terms of Rule 9241D of Railway Establishment Manual. Now, his basic pay, which we was drawing, was 5375. His basic pay was fixed. Last page, if Your Honor turns to page 5, his basic pay was fixed at 5250. Then he was given one increment. Then his pay was 5375.
Understood. Yes, Mr. Dilip Prasad.
Yes, my lord. Now,
Now,
I am
just
not.
let me read. Complete. Let me complete para 11. 5375 was the basic pay he was drawing. Only 30% basic pay running allowance as per rule, relevant rule was added. Then one notional increment was given. The total amount is 1,71225. Therefore, his pay was fixed at 7250. So when he was promoted to the post of section controller, he was given a benefit of 30% running allowance as per Rule 9241D, and his pay was fixed as 7250. And the reason for this drastic change is only one, because of the drastic increase in the pay scale, which I have stated.
Yes, we have seen that.
Huh. So I have explained everything. He was rightly given benefit of 30% running allowance by fixing his pay under fifth pay commission, and then he was promoted.
Yes,
So
we
everything
have.
has been done in accordance with law. That is my submission.
Prashad?
My lord, yes, my lord. I do admit the statement made at para 11 as correct. Still,
Yes.
I will be posing for a moment, my lord. I have not denied in my counter affidavit this very statement, which is the means of calculation for fixation of pay. Now, your lordship will get it. Quota with effect from 26 to 97. Has your lordship got it? The fourth line, 26 to 97.
Yes.
With the benefit of 30% allowance on 26 to 97. Again, the word 26 to 97 is there. This is the statement given on oath by the respondents themselves. Now I draw your lordship kind attention towards paragraph 15 of this very counter affidavit. What is the jargon being created is obvious from this paragraph. Para 15. Now it is humbly stated and submitted at the time of fixation of pay of respondent for under fifth pay commission on 1/196. He was entitled for 30% of basic pay. It is contradictory. Both statements are contradictory on 1/196. It has not been shown in paragraph 11. That is what I am harping. 26 to 97, 30% of given to him, as was given to this petitioner on 193 when he was posted to the controller, section controller. Now,
No,
furthermore,
the
running
answer,
allowance.
the answer could be, Mr. Modi will enlighten. The answer could be that the fifth pay revision was implemented later on with effect from 196. So the
That is
calculation payment was done later on under fifth pay revision, and then based on that, the promoted scale as on 26th February 97 was calculated.
my lord. My submission is again for consideration before this honorable court is paragraph 15. I am permitted to read it. 1/196, he was entitled for 30% of basic pay as running allowance. He was entitled to. And therefore, paragraph 11 stands in contradiction to each other. Because this 30% allowance has been admitted to be given on 26 to 97 when he was put to the stationary post.
So
So
that we
this
have asked.
30% allowance cannot be. Number two, they have admitted it in the same paragraph. Good as section controller on 26 to 97, his pay was again fixed at 7250. As your lordship got it, 7250. In the post of section controller, after giving benefit of 30% running allowance, as was done in the case of the petitioner as section controller. Similar position. Therefore, petitioner cannot make any grievance regarding pay fixation of respondent 4 on 1/196 as per fifth pay revision and on 27 to 97 after promotion to the section controller, which your lordship has just now suggested me. This would be the reasoning. Anomaly has occurred because of drastic increase in the pay after implementation of fifth pay revision, and therefore 30% of basic pay as running allowance of substantive amount. Now these two paragraphs, I have responded, your lordship will come to my reply. Rejoinder to this affidavit, my lord. Paragraph 16, my lord.
नहीं आपको रिजॉइंडर कब फाइल की?
Yes, this was filed, my lord, on 9/2/22.
That has been not cleared from record. क्या क्या लिखे हैं उसमें पढ़िए.
Paragraph में हमने लिखा that the statement at para 21 and 22 are as such admission on their part of this counter affidavit, and charge shown in earlier counter affidavit dated 11/10/19 of giving twice the benefit of running allowance is false and contradictory as well. Para 6 of rejoinder dated 16/12/20 has not been denied. Para 17, that the statement at para 23 is specifically denied on account of the fact that anomaly has not occurred due to two different posts or different cadre, as because both were goods guard and promoted to section controller. And on the pay revision on 28/2/97, DK Mishra got rupees 7,250 in the scale of 5,500 to 9,000, and petitioner on 28/2/97 got 6,700 in the scale of 6,500 to 10,500. This is the crucial issue wherein the difference took place. 30% allowance once to both, but when his pay was fixed, it was 7,250, whereas the petitioner 28/2/97 6,700. This is the anomaly which I wanted to get it stepped up in terms of Rule 9. Because junior is getting higher pay scale, senior is getting lower pay scale. Now, I draw your lordship kind attention towards the annexure 4 of my original writ application, my lord. Page 32. Of the writ petition, my lord.
Yes.
Note 9. In cases where a senior railway servant promoted to a higher post before the first day of January 96, he was promoted in the year 93, draws less pay in the revised scale. I am getting 6,700, he is getting 7,250. Then has junior who is promoted to the higher post on or after first day of January 96. He was promoted in 97. The pay of senior railway servant should be stepped up to an amount equal to the pay as fixed for his junior in the higher post. So in the higher post his pay was fixed 7,250 and my was of 6,700. The stepping up should be done with effect from the date of promotion to the junior railway servant, subject to the following fulfillment of following conditions, namely A. Both the junior and senior railway servants should belong to the same cadre, and the post in which they have been promoted should be identical. Both were goods guard and promoted to the section controller. Now B. The pre-revised scale and revised scales of pay of the lower and higher post in which they are entitled to draw pay should be identical. I was getting also 1200 to 2040. Goods guards also same, 1400 to 2600. Number C. The senior railway servants all the time at the time of promotion have been drawing equal or more pay than the junior. I was drawing more pay. It was not equal. Now D. the anomaly should be directly as a result of the application of the provisions of Rule 13(1)(3)(f), F22 of Indian Railway Establishment Code, Volume 2, or any other rule or order regulating pay fixation on the such promotion in the revised scale. So, in the promotion revised scale of D.K. Mishra was 7250, whereas this petitioner got 6700 only. And on such promotion in the revised scale, even in the lower post, the junior officer was drawing more pay in the pre-revised scale than the senior by virtue of any advance increments granted to him. Provision of this note need not be invoked to step up the pay of senior officer. So, according to this rule, the anomaly has occurred on the fixation of the pay, which stands admitted at paragraph 11 of the counter affidavit, latest counter affidavit, but for misleading or making a false statement, para 15 is again reiterated the earlier, wherein the Lordship's query was under what circumstances he was given twice 30% of the allowance, which is categorically missing in para 11, which I have not disputed, not denied. If your Lordship only goes to the 11, 10, 19 affidavit, wherein page paragraph 10 they have disclosed it. Pay fixed in fifth CPC in rupees 4. Yes,
Mr.
Milord.
Prashant, page 32 is part of annexure 4 and page 31 is a gazette in Hindi and page 32 starts from English. So there is no
Yes, Milord.
continuity.
Yes, your Lordship is correct. There is no continuity for the reasons that I have taken shelter of this very particular note 9 of 7.
How can we straight away rely upon a what you call truncated
If your
document?
Lordship does ask me to provide the entire, because your Lordship is aware, while stamp reporting, we are put into a lot of problem by removing the defects.
So
For
this
the
will be an
purposes of
initial.
stamping. If your Lordship accords me time of at least 2 weeks, I will be providing by the supplementary affidavit, which will be not the subject matter of stamp reporting, my Lord.
So what we do is to we will admit this application, hear it properly. In the meanwhile, you file a complete annexure gazette.
Yes, I'll do that, my Lord, because only hurdle which I do face as a lawyer, my Lord, of the stamp reporting. Several paragraphs and the
File
old notifications are there, which could not be
supplementary
typed
affidavit,
properly.
bring it on
But the
record
fact
by way of.
remains,
My Lord, may I submit? The tribunal in this order has taken note of para 9 and dealt it.
We will deal with it.
If Your Honor permits, I can read that. If Your Honor wants to admit, I have no objection to it. But I think it can be disposed of. The tribunal has taken note of para 9 which he is now placing. It has been quoted in the tribunal's order also.
and then the
He
second
has
wage
not
order is,
quoted, the tribunal is not quoted the entire thing, but only A, and then it has dealt in para. Page 40, if you're on para D, page 41, para F. From the above enumeration, it is palpably evident that Note 9(1) of Rule 7 of Railway Service Revised Pays Rule 1997 cannot form the basis for providing reliefs to the applicant who is clearly arguing under a misconception, claiming emoluments which were neither part of his service trajectory status nor the result of the comparison between the two similarly situated persons. Admittedly, both the applicant and the private respondent, number 4, were appointed together and the applicant was clearly senior to the private respondent, number 4. However, their career have moved on two different levels, with the applicant moving at a faster pace. Therefore, at this point of time, he is only entitled to consequential benefit of his service and he cannot keep looking over his shoulders and claiming higher scale of pay by attempting illogical comparison that the career of private respondent has moved at a different pace and level and he is today getting the benefit of his service as per his status. To the to the extent the applicant and private respondents are no longer equals and not similarly situated, claim of injustice or discrimination are not sustained. This is how the tribunal has dealt with.
Yes, my lord. In response to such submissions, my lord, in the first way, there is no twice running allowance stated by the authorities concerned. Number two, the second way, paragraph 7. Paragraph 7 says, my lord, dismissed by order dated 27/6/16. We have perused the said order of the tribunal. We find that the dismissal of the same OA was not on the basis of merit, but on the ground of limitation.
My lord, this is
This
again
is
wrong.
also the
If your honor comes to page 42, para 7, I will read it. It is dismissed both on merit and limitation. This again is
that's why this tribunal was
46 is
erroneous.
again a wrong recording of by the tribunal.
Recording of
Para 7,
then
page 42.
why you have not challenged this part of the order?
Why should I?
Hmm.
We have
And
understood.
this 30%. Yes, my lord. And then practically I am speaking one line more, my lord, that this 30% twice being given was never agitated before the CAT, which is per se illegal. Paragraph 11 and 15 stands in contradiction to each other.
For learned counsel for the parties. The writ petition is directed against the order dated 27th June. Please mute yourself. 27th June 2016 and 9th August 2018. Passed in OA number so and so by learned CAT Patna Bench Patna, Circuit Court at Ranchi, Circuit Bench at Ranchi. Annexure 5 and 6. Stop. The dispute relates to claim of pay parity or rather claim of stepping up of pay on the part of the applicant, which has been declined by the learned CAT. Stop. The legal issue open for consideration was framed by this court on 25th February 2020. Stop. Since the matter related to pay fixation and lies in the domain of financial experts, the Comptroller and Auditor General of India was impleaded as a respondent and asked to file its response. Stop. The order for better appreciation, the order dated 25th February 2020 is quoted hereunder. Stop. and the CAG conducted an audit exercise concerning these two employees, the applicant and respondent number 4. And an affidavit of the respondent CAG.
3rd of December 2020, Your Lord. Para 11 is my reference.
Gives a picture of their audit exercise. It gives a picture of the result of the audit exercise. Para 11 is quoted here under. Stop. Single space. The learned, when the matter was taken up on 4th January 2022, Railways sought time, then Counsel for the Railways, Mr. Pradeep Kumar Modi, sought time to seek instructions made by this court in its order dated instructions on the specific observations made by this court in the order dated 25th February 2020. Stop. A counter affidavit has been, supplementary counter affidavit has been filed on 28th January 2022. A rejoinder thereto has also been filed by the petitioner. Stop. Learned Counsel for the Railways has taken us to the relevant provisions of the Railway Establishment Manual Volume 1 within bracket 1989 edition, Rule 924, para small I, small d within bracket. Stop. He has also taken us to the notification of the Ministry of Railways within bracket Railway Board dated 8th October 1997, RBE 1 number 133 of 97, which provides for pay fixation, a fixation which Rule 7 whereof provides for fixation of initial pay in the revised scale within inverted comma, fixation se skip that. Under the railway services within bracket revised pay rules 19, revised pay within bracket rules 1997. Stop. The Council for the Railways has in particular referred to sub rule 1A and B, capital A, capital B, to explain how the 30% additional allowance has been granted twice to the private respondent while fixing his pay on 1196 upon 5th pay revision and thereafter again on his promotion as section controller with effect from 26 February 1997. Stop. These additional running allowance has basically the grant of the second running allowance slash special pay running allowance has in effect resulted in the grievance of the petitioner. Stop. It is his case that both the petitioner and the respondent number 4 got promoted as section controller on different dates, that is 7th September 1993 and 26th February 1997. And thereafter, the respondent number 4 and on his promotion as the section controller in February 97, there was no basis to grant special allowance in the nature of running pay element to him once he had been granted that benefit with effect from 1/1/1996. Stop. Learned counsel for the petitioner has submitted that para 15 of the counter affidavit of supplementary counter affidavit, last supplementary counter affidavit of the respondent runs contrary to the statement at para 11, in particular small a, depicting the basic pay as guard of the respondent number 4 on 26th February 1990 scale 7 in the scale rupees 4,500 as 125 plus 7,000 equal to 5375. Stop. Learned counsel for the petitioner has also referred to the extracts of rule annexure 4, in particular note 9, which provides for stepping up of pay of a railway servant promoted to a higher post before the first day of January 1996 in case he draws less pay in the revised scale than his junior who is promoted to the higher post on or after the first day of January 1996 subject to fulfillment of conditions small a to d. And clause 2. Stop. We have considered the submission of learned counsel for the parties. It is suffice it to say that this issue of stepping up of this claim of stepping up of pay on the part of the applicant was raised by him after considerable delay in the OA referred in the year 2014. Though the learned cat, even after noticing the delay, went on to examine the claim on merits while ultimately declining the same for reasons contained in paragraph 6 of the impugned order dated 27 June 2016. Quoted here under. Stop. His applicant made another attempt to rake up the same issue in OA 051/00184/2016, which was dismissed on 9th August 2018 by the learned CAT, holding as under. Para 7, page 45. Stop. We have considered the case of both the parties in the light of the relevant rule position and we do not find any reason to interfere in the CAT's order. We do not feel necessary. We are of the opinion that no interference is required in the orders impugned, order of the learned CAT impugned herein, for the following reasons. Stop. A. Applicant, as on 119, applicant who got promoted as section control on the 7th September 1993 and got the benefit of 30% of basic pay as junior running pay element of running pay element, got once again promoted as deputy chief controller with effect from 1/1/96. Twenty-nine 396. 23/9/396. Stop. The cadre of the petitioner and respondent became different from that day. Stop. Respondent number 4 continued to be in the running cadre as he was working as goods guard till 26 February 97. The RBE number 133, सबको सब पैरा करते जाइए, 133/97, which has been referred to, which was referred to in our order dated 25th February 2020, was apparently placed in, has been extracted, has been brought on record through the supplementary counter affidavit of the respondents. Stop. The relevant extract of Rule 7, 1A and B, capital, are quoted here under. Stop. Upon implementation of the fifth pay revision with effect from 1/1/96, petitioner, respondent number 4 was granted the special pay allowance of 30%, which brought his revised pay to rupees 5177, or equal to rupees 5250 with effect from 1/1/96 as per the chart at para 10 of the supplementary counter affidavit extracted here under page 5 से chart कर लीजिए. However, the respondent number 4 continued to be in the same running cadre, being goods guard, till he was promoted as section controller on 26 February 1997. Stop. Then came the application of Rule 924 small I small d of the Railway Establishment Manual within bracket volume 1, 1989 edition. It is quoted here under this paragraph. Page 16, supplementary counter affidavit. Yeah. Rule 924I small d provided fixation of pay in statutory post, in stationary post, and 30% of basic pay of running staff as running allowance. Stop. This 30% of basic pay was granted to the petitioner when he was promoted as section controller with effect from 7th September 1993. Stop. However, his cadre changed upon his promotion as Deputy Chief Controller in March 1996. Stop. Petitioner and the private respondent since then became incumbents of two separate cadres. Stop. As such, the ingredients of Rule Note 9 relied upon Note 9, which is part of RBE 13397/97 at page 32 of the writ petition, would not be applicable. Yep, sentence carefully.
As an ingredient of rule, note 9.
As such, Note 9 of RBE 133/97 at page 32 of Annexure 4 became inapplicable to the case of the petitioner. Stop. Clause A thereof required that both the junior and senior railway servants should belong to the same cadre, and the post in which they have been promoted should be identical as the same cadre. Stop. Petitioner had become Deputy Chief Controller prior to the promotion of the respondent number 4 as Section Controller. Stop. Respondent number 4 had continued to remain in the running cadre. Stop. Learned Central Administrative Tribunal had taken note of Note 9 at paragraph 6 small f of the impugned order quoted above of Rule 7, Rule 9 of Rule 7 of Railway Service Revised Pay Rules 1997 at para 6f of the impugned order also quoted above. Stop. The reasoning of the learned tribunal therefore appears to be on the correct lines. Stop. Petitioner has, on a mistaken impression, pursued his claim for stepping up of pay dating back to 1997 when respondent number 4 was granted 30% more 30% running pay allowance for the second time on his promotion as section controller. Stop. The claim, though, was still but has been examined on merits by the learned CAT. Stop. On reappreciation of the materials on record, we do not find any error in the impugned order warranting interference at this stage. Interference under Article 226 of the Constitution of India. Accordingly, the writ petition is dismissed.
Item 30, WPS number 6744
Yes. Yes, my lord.
Yes, Mrs. Paul.
Yes, my lord. In this case also, my lord, the order passed by the learned tribunal is under challenge, that is page 23. Matter is, my lord, with the non-payment of the subsistence.
May I interrupt your lordship? There is an IA application filed by the respondent, lordship.
In this case, my lord, kindly see the order dated 2/3/2020. There is an order, my lord, directed to file the counter affidavit within such and such. If not, first week, cost may be imposed. That was the order.
For that, I have filed an IA application, lordship, in this case. IA number 4226 of 2020.
Copy has not been served to me.
In this, lordship, I pray for exemptions of the cost, lordship. Also,
we will condone it because of the lockdown.
Yes, that is the situation. I can't say anything. Situation. But now they can file it whenever within a specified period. Then this case will be decided because the question involved in this case already decided by the Honorable Supreme Court, and the order passed by the London Tribunal is contrary to the decision so far the suspension subsistence allowance is concerned. The findings of the London Tribunal, the relation, there is no relation during the suspension period, and he is not entitled for the subsistence allowance unless non-employment certificate is written and he is remain in the headquarters and put his signature attendance in every day. That is not the rule, and that should be decided according to the Supreme Court decision is fully covered by my case.
So this petitioner has filed a writ petition number 7258 of 2016, which was dismissed for default.
Dismissed for default? No.
Because of no defect.
I have no information.
That is, order is at page 20 of their counter affidavit.
Counter has not been served to me, my lord. Counter has not been served to me.
Mr. Chakravarti, you serve it upon him?
Yes, I shall verify. If that is the situation, I don't know.
Lordship, if it is not served, I will serve, lordship. Generally, we serve the counter affidavit.
It has been filed with a note. The notice has a note by your advocate clerk. Counsel for the petitioner is not available, and as well as clerk is also not available. The copy of the same.
During COVID period, it has been filed. I will serve the copy, lordship.
Serve it, and Mrs. Paul, you find out if there was an earlier writ petition for the same cause of action.
Yes, I shall verify. If it is, then that is something that is I have to verify.
And counsel for the respondent railways undertakes to serve copy of the counter affidavit and the IA number 4226 of 2020 upon Land Council petitioner by Friday.
Lordship.
Positively. Matter be listed after 1 week.
Much obliged.
After 1 week, I may not be here, therefore, my lord.
Yes, Mrs. Paul?
My lord, if possible, my lord, after 2 weeks, I may not be here after 1 week. That's why, sir.
After 2 weeks.
Yes.
Item 14, number 20 of 2019, Mr. Samsekar Kodapalli, Mr. Mohammad Jassim, Mohammad Fatah.
My lord, in this case, my lord, I appear for respondent, my lord. I pray 4 weeks time, my lord, for filing the counter in this case.
Counter इसमें tax appeal में क्या है?
It's a tax appeal, your lordship. May I just submit, your lordship? The issue, the question of law involved in this tax appeal is as to whether the core question of law involved is as to whether, in absence of any specific opinion or view formed by the assessing officer in the assessment, with respect to addition under section 68, can it be said that the opinion has been formed, and as to whether the assessment order is erroneous so far as it relates to prejudicial to the interest of the revenue? Hence, action taken under section 263 of the income tax is absolutely correct and legal in view. Now, moving forward, the facts of the matter, your lordship. What happened in this case in the year 2013, on 28/9/2013, return were filed showing and declaring an income of rupees 10,36,390, and thereafter the case was
Wait. We'll frame this substantial question. In substance, the case is that CIT.
not CIT, your lordship.
No. Under 263.
Ji.
Under 263, the CIT was of the opinion that the creditworthiness and genuineness of the unsecured loans from the depositors were not duly verified by the AO.
Yes, your lordship. Not verified, and not even inquiry was taken place.
This was necessary in view of the amendment made in explanation 2 to section 263 of the IT Act with effect from 1st June 2015.
Yes, your lordship.
Apart from the general principles, and ITAT has set aside that order of CIT, holding that these 4 items, source and details of introduction of capital with evidence, reasons for increase of unsecured loans, all these bank accounts and audit reports were produced by the SEC.
Yes, your lordship.
But he did not try to find out as to how the 2 persons, Rajesh Chaurasia and RC distributors, whose returns were there, from where they got so much of money to invest or deposit it with the SSC.
Absolutely, your lordship. There is a specific finding by the CIT in its order under section 263, wherein he has also relied upon the return filed by the Rajesh Chaurasia, and only merely because of the bank statement the assessing officer was produced before the assessing officer, no inquiry, nothing was made. I have also forwarded one judgment in this point, your lordship, of your particular court itself, wherein it has
law have not been framed in the proper manner. Otherwise, we would have straight away.
Yes, your lordship. The following, your lordship, it may be indicated in the order. The second substantial question of law, which has been framed at page 10, is important, and the other I will be. May I just submit, your lordship, what should be the?
Whether in the facts and circumstances of the case and in law, the learned ITAT is justified in setting aside the order passed under section 263 of the Act by the CIT. Though AO had not carried out the verification of the depositors.
Your Lordship, may I?
Yes.
Verification and inquiry, Your Lordship.
And inquiry, sorry. Verification and inquiry as to the creditworthiness of the two depositors in particular, as was also required under explanation 2 to section 263 of the IT Act 1961, introduced with effect from 1st June 2015. The main question.
Yes, Your Lordship. Three quote whether on the facts and circumstances of the case and in law, the learned ITAT was justified in holding that the assessing officer had duly verified the genuineness of the unsecured loans, especially when the depositors in question were prima facie creditworthy to lend unsecured loans. Question. Genuineness of unsecured loans. These are sufficient. One more, Your Lordship, the question of law, whether in absence of any specific finding by the assessing officer, can it be said that the assessing officer has formed any opinion in this regard? If Your Lordship feel.
No, that.
Because
opinion, that will be a change of opinion.
no finding at all has been there in the assessment order. Nothing has been there.
So that will not be a question of law.
But the ITAT has held that the opinion has been formed. It is sufficient that the opinion has been formed. ITAT has went on stating that the opinion has duly been formed by the assessing officer, even though it is not there in the assessment order indicated.
The observations of the learned ITAT that the assessing officer had formed an opinion as to the creditworthiness and of the deposit transaction is perverse on facts and in law. Admit call for the lower court records in connection with so and so ITAT ka, CIT ka or AO.
Much better, Lordship.
ITAT or CIT? ITAT or CIT ka records.
Much of
May it please, Millards. Millards, in a substantially similar matter, which is tax appeal number 22 of 2019, Millards have already framed questions of law wide order dated 14 December 2020.
ये टैक्स अपील 22 of 2019 में 14 दिसंबर का जो ऑर्डर 2020 का वो एग्जैक्टली इसमें कर दीजिए और इसको टैग कर दीजिए.
And you take previous cases of, अच्छा don't tell them.
ये
बच्चों में पेरेंट्स मुझे रिपोर्ट
क्या नाम हुआ आपका?
आकांक्षा मित्तल जेसी टू सुमित गारोडिया मोशन.
जेसी टू मिस्टर सुमित गारोडिया. ये ऑर्डर में
Except the delay part in that order will not come in this order, Millards, because delay has already been condoned in this matter.
Delay force.
Perhaps from para 4.
Para force.
Much obliged, Millards.
item 6 is year number 34 of 2019. The supplementary for the appeal, Mr. Mahendra Kumar Chaudhary.
May I please, Your Lordship? In this, the tax effect is below the monetary limit, so I will be filing an application in this case for withdrawal of this, if required.
When you file writ appeal, again you file withdrawal.
And IA will be filed, Your Lordship, so that I have already sought for an instruction which is still awaiting.
अच्छा वो
Filing होना चाहिए ना, ऐसा लगता है इसके लिए money है, energy, उनका substitute.
Your Honor, we are appearing on behalf of the respondent in this matter, Your Honor.
Learned counsel for the applicant, Ms. Amrita Sinha, submits that instructions have been sought as to the tax effect of the impugned order, whether it falls within the monetary limits for preferring the appeal before this court. Stop. It appears from the order at Annexure 2 that Annexure 2 is the order passed by the Commissioner of CIT Appeals, Hazaribagh, which indicates the tax penalty amount as rupees 78,63,030. Stop. Department should have applied itself as to whether, before preferring the appeal, as to whether the tax effect of the impugned order falls within the monetary limits of the court. Monetary limits for preferring the appeal before this court, as per their own circulars, as per their own circular that department instruction. Our one indulgence is granted to counsel for the appellant to bring on record necessary statement regarding that.
May I just
Yes.
submit, Your Lordship, when this appeal was filed, at that moment the tax effect was above the monetary limit. However, subsequently, by notification dated in August 2019, the tax effect was increased to 1 crore. Earlier, it was 50 lakh.
Your Lordship, the circular will be.
Interest plus penalty is 78 lakhs. Anyway,
Your Lordship,
List it in the list it on 7th March.
7. The same is with respect to the next matter, Your Lordship, serial number 17, also on the same issue.
17 में भी भाई लिखिएगा, लेकिन Annexure 2 उसमें तो दूसरा
इसको 19 लाख फर्स्ट में है। इसका ग्राउंड में 50 लाख।
The issue involved in this was 234B, Your Lordship.
230.
Whether interest is payable on the return income or the assessed income, that issue was there only.
In that case, why you file appeal?
Yes, Your Lordship, I completely agree with you.
7th March वो पैराग्राफ इसमें नहीं रखिए। यार लिख दीजिए इसमें भी income tax penalty demanded is 19,55,080 as per the order of the CIT appeals and Jharkhand. बाकी सब वही है।
Much obliged.
Item 18, first appeal number 5 of 2020 is the same last order of
Yes, I am appearing on behalf of the appellant.
Yes.
Unless it was sent for mediation and perhaps they have agreed to certain terms.
They have decided to live together.
Yes, but they are.
Yes, Your Lordship, I am appearing on behalf of the husband in this matter, Your Lordship. Perhaps good sense has prevailed between the parties. The matter was referred.
So in that case, we will should we incorporate the terms of the settlement in the order and then you either we dispose of the appeal or you withdraw the appeal?
That can be done, Your Lordship.
Disposed of, it can be disposed.
Part of the decree हो जाएगा. बड़ी खुशी रहना चाहते हैं बच्ची बात कराने का अच्छा बना रहेगा देखते बच्ची के से चुपके रखना होगा कर देंगे महीने कम से कम वो मेल से अच्छा हाँ 26/16 8 of 2019 ये दूसरा चीज हाँ देखिए मिस्टर Sumit Prakash for appellant, Mr. Vikas Kumar for respondent. The appeal was preferred by the respondent wife on dismissal of the original suit number 26 of 2016, while impugned judgment dated so and so, passed in so and so. Judgment so and so, passed by the court of so and so.
Perhaps she was the petitioner. Sorry for interruption, Your Lordship. She was the petitioner before the learned lower court.
That is what I'm saying. The suit preferred by the appellant, petitioner appellant, was dismissed. Stop. The petitioner had prayed for divorce on the ground of cruelty and desertion and also permanent alimony. Stop. Parties were referred for mediation during proceeding pendency of this appeal. Stop. Mediation has been successful as per the report of the learned mediator Jhalsa bearing letter number 50 dated 5th January 2022 enclosing the terms of settlement arrived at between the parties under their joint signatures. Stop. Both the parties have decided to live together with the children as per the terms and conditions agreed between them. Then counsel for the parties has upon instruction submit that the appeal may be disposed of in terms of their settlement. As no matrimonial dispute survives, parties undertake to abide by the respective terms, by the reciprocal terms agreed between them as contained in the settlement. Stop. Original suit 8 of 2019 is about what? Having regard to the arrived at between the parties during mediation and on consideration of the prayer made by learned counsel for the parties, we are of the view that no useful purpose could be served by keeping the appeal pending for adjudication on merits. Stop. As such, the appeal is disposed of in terms of the settlement arrived at between the parties dated 5th January 2022. Settlements, though, stop. The settlements are in two parts. Stop. Both of them shall form part of the decree. Stop. Decree accordingly. Lower court reports आया हुआ तो LCR है.
Much obliged.
या तो 2021 का कॉल कर लीजिए. फर्स्ट अपील जरा कॉल कर लीजिए 2020.
Item 20, Article number 22 of 2021, Mrs. Chandana Kumari for the appeal.
Your Lordship, I am on behalf of appellant. In this case, Lordship, notice has been issued to opposite party.
Notice has to be issued.
The present appeal is against the judgment dated 4/2/2021, passed in original suit number 502/2017 only.
Issue notice on the respondent under registered cover with heading and ordinary. A speed post, registered cover with heading speed post and ordinary process, for which requisites be filed within 1 week.
Item 21, Article number 26 of 2021, Mr. Mukesh Kumar for the appeal. Mr. Rai News for the appeal.
Yes, Lordship, I am appearing on behalf of respondent, Lordship. Lordship, I pray for not today, Your Lordship.
Go for mediation.
Yes, Lord.
You can go for
Yes,
mediation.
Lordship.
Respondent has entered appearance on notice through Wakalatnama. Stop. And counsel for the parties agree that an effort for amicable settlement of the matrimonial dispute between the parties can be explored through mediation at Jalsa at this appellate stage also, since the marriage is of the year 2010 and no children are born out of the wedlock. Stop. Parties are willing to attend mediation physically at Jalsa.
Physically at Jalsa.
Stop. That be of the parties appear member secretary Jalsa. 4th March 2022 at 10:30 a.m. The member secretary can be also approached on the following numbers. On their appearance, matter be placed before the mediation for undertaking the. Since the respondent has to come from far off,
Chhattisgarh, Your Lordship.
mediation can be held on subsequent dates. The initially can be held on subsequent date. Stop. Parties are expected to नहीं, mediator would endeavor to fix the subsequent sittings as per the convenience of the parties. Stop. Appellant shall pay a sum of rupees 3,000. 3,000 towards travelling and incidental expenses for each date. On each date, the respondent attends the mediation proceedings, in the presence of learned mediators Halsa. Both the parties are expected to cooperate with an open mind and attend each of the sittings. If they are able to arrive at an amicable settlement, terms and conditions thereof be reduced in writing under their joint signature.
Lordship, I want to make one submission, Your Lordship, may permit it. Lordship, there is dues in 2,34,000 dues in maintenance case. There is also a maintenance case, and that is dues amount is there, Lordship. So kindly, Your Lordship, maybe order for the release the same dues amount for maintenance.
Not now. First, you mediate amongst yourselves.
Okay. Much obliged.
This is the case on in the week of 25th March, along with the report.
Much obliged.
मेरा लिस्ट चलाएंगे. Yes.
Item 32. First topic about 27 of 2021, Mr. Rahul Kumar or the.
My lord, I am appearing for the appellant wife in the instant matter. The instant appeal has been preferred against the judgment of divorce and decree. Notices have to be issued to the husband, my lord.
Issue notice on the respondent under registered cover with AD and speed post. On the present address at Bokaro, an ordinary process on the present address at Bokaro, and also under registered cover with speed post at his permanent address in Vaishali, Bihar, for which requisites be filed within 1 week.
2 weeks, my lord.
2 weeks.
Much obliged, my lord.
Yes.
Item 23, first appeal number 28 of 2021, Mr. Varun Kumar Singh for the appeal, Mr. Sanjay Prasad for the.
In this case, Lordship, I am appearing on behalf of the appellants, Lords. On Lordship, 13/12/2021, Lords. Lordship, I refer Lordship this matter before the Jhalsa, Lords.
Mediation has failed.
Yes, Lords.
Mediation has failed as per the report of learned mediator Khalsa bearing letter number 43 dated 5th January 2022. Admit call for the lower court reports in connection with so-and-so from the court of so-and-so. Place the matter under the heading for hearing upon receipt of the LCR as per its age.
Right.
अभी ये जो इमीडिएट एक पास हुआ ना उसको करिए 19
Also, case item 9, WPC number 1106 of 2020, Mr. Prasad for Mr. Rahul is submitted.
May it please the court, Lords.
Yes.
Lords, appearing on behalf of the petitioner, Lords, the instant writ has been filed for quashing of the notice dated 4th of February 2020 and 24th of February 2020, Lords.
Right.
At page number 69 and page number 80, Lords.
So during pendency of the writ petition, the order under section 260
Lords has been passed, Lords.
So you prefer an appeal?
Lords, one small submission, Lords. I may be allowed to just place one document, Lords.
Whatever it is, you are taking the point of jurisdiction that the order of transfer from Hazaribagh to Kolkata was passed, but the order has under 263 has already been passed. You take this ground in appeal.
May I also submit, Your Lordship, that the jurisdiction, although they are stating that the jurisdiction was transferred from Hazaribagh to Kolkata, but on the very same day, Kolkata returned the file to the Hazaribagh, stating that in the old matters, as the assessment and in the entire thing has been done by the Hazaribagh PCIT, therefore the further proceeding we also held. So there is no such question of jurisdiction also over in the facts of the case. I have not filed the counter in this matter, and rightly the alternative remedy is already there under section 253, so they can prefer an appeal against the reassessment order. Your
Milords, at least this fact may be brought on record by them, Milords. So
it's not required, Your Lordship. These are the internal things, and it will be bring on record if it has been raised in the alternative remedy before the assessing officer, Your Lordship. The jurisdiction is not the issue involved in this matter, Your Lordship.
Can we record your statement, Ms. Amrita Sinha?
Yes, Your Lordship. It may be recorded, Your Lordship.
Then you avail of the alternative remedy. We will
Milords, in
indicate
that,
your
Milords, that liberty may be granted to raise the issues before the
petition was preferred for the following relief. Para 1, A, B, C, D. A, B, C, D, E. Stop. However, during pendency of the writ application, the
Milords, page number 15 of the IA, Milords.
Principal Commissioner IT, CIT, Principal Commissioner IT Hazaribagh, Income Tax, PCIT Hazaribagh has passed the final order under section 263 of the IT Act 1961 on 23rd March 2020. Stop. The order is appealable under section 253(1)(c) before the ITAT, Income Tax Appellate Tribunal. Stop. Then counsel for the petitioner had raised jurisdictional issues as according to him, the jurisdiction of the SSC was transferred to the office of PCIT Kolkata, Ward 1 within bracket 3, Kolkata, by an order dated 25th April 2019, annexure A by 2 to the IA number 3479 of 2020 seeking amendment. Stop. वो जो order है PCIT जो हम बोले ना A by 3 उसको कर दीजिए. Stop. Our learned counsel for the respondent revenue on instructions submits that immediately on such transfer, the file was returned by the PCIT Kolkata to PCIT Hazaribagh because all the files relating to the SSC, all such old files relating to assessment were lying within the jurisdiction of the PCIT Hazaribagh. Stop. It is submitted that the petitioner has an alternative remedy of appeal before the ITAT. Stop. Therefore, the writ petition may not be entertained. Stop. Then counsel for the petitioner then seeks permission to withdraw the writ petition in order to approach the in order to prefer an appeal before the ITAT.
Milords,
Section 253(1)(c) of the Act.
Milords, I'm so sorry, Milords. Milords, I don't know if it has not already been preferred, Milords. That may be indicated.
If not already preferred. stop. So there will be some delay. You have 253.5 also for completion of delay. The petition is dismissed and withdrawn. Stop. It is open for the petitioner to pursue the alternative remedy of appeal if permissible in law. Yes, good.
Like minutes.
24.
Item 24.
Look, sir, I'm appearing for the petitioner in this matter. Look, sir, I have my own belief that the state may not be protesting the writ application now in view of my lord's judgment in NKAS case. I have sent the paper book of judgment. Today morning itself I have sent minutes.
Mr. AG2, who is appearing?
Minutes, I think minutes, Deepak Dubey was appearing, I believe.
Mr. Deepak Dubey doesn't appear in tax matters.
But he's here, he's here.
He is another passed over matter. Where is Mr.
Dubey, your
Mr.
phone is
Dubey?
mute.
74 and 73, both orders are there now.
No, 73 is there, not 73. Because the proceeding was initiated in the 73 minutes.
No, I'm saying that we have quashed the...
Yes, absolutely. Both orders there. But the second matter, the order has not yet been uploaded. So I am not equipped with that order, minutes.
Perhaps today or tomorrow it will be uploaded.
Yes, minutes. So I do not know if at all they would be contesting or not.
Yes, Mr. Dubey. In item 24, Mr. Sachin Kumar, your senior, is appearing. Where is he? Mr. Dubey, are you hearing us? Unmute.
Kindly unmute your microphone.
I'm sorry, Your Lordship, my mic was not functioning properly, Your Lordship.
Yes, so item 24, where is AG2?
My Lord, he is in court number 13, Your Lordship.
What are your instructions?
After 2 or 3 cases, Your Lordship, I will inform him, Your Lordship.
This was a short matter.
Look, I have raised 2 issues.
Yes.
Look, there are 2 issues involved in this matter. The first is with regard to the manner the proceeding has been initiated without opportunity, summary order has been passed. Though my explanation was there, it was not considered, not a whisper about my explanation. And based upon the summary order, my electronic credit ledger has been booked for almost 2 years. So these are the 2 limited issues. My lords have already decided these issues. If at all the state is not contesting, then it can be disposed of in terms of NKS and Valerius Industries. And if they are contesting, then I will argue out the entire case.
Then pass over for few cases because Mr.
Fair enough.
Sachin.
No difficulty. No difficulty.
Lord, in this matter, I am led by my counsel.
Please, my lords. I am appearing with my learned friend, Mr. Garude, my lords.
Yes.
My lords, this petition challenges the adjustment of certain refunds which was determined payable to me against what the department alleges were outstanding demands without complying with the procedure as mandated by the Income Tax Act, my lords. My lords, under section 245 of the Income Tax Act, the department has a right to adjust refunds, but it has to give prior intimation of its intention to do so. If my lord will just see section 245 of the Act, my lords.
What we have gathered, Mr. Pardiwala, from your readings.
Yes, my lord.
3 years involved.
That's right.
16, 16, 17.
That's right.
For 14, 15, it's your contention that 20% amount already deposited, in fact, more than 20% amount already deposited.
That's right, my lord.
Stay from coercive steps operating. The rest of the amount was not to be adjusted against tax dues of that year.
That's right.
16, 17, perhaps your case is that you did not get even 30 days time to pay the demand and it was accepted on 23rd April.
That's right.
15, 16, I am a bit missing the relevant sequence. What is your argument of 15?
There my argument is my stay application was pending, and pending disposal of a stay application, how could they adjust the refund? Because otherwise you are rendering my application infructuous.
No, one stay application perhaps was rejected.
No, my lords, that was for, my lords, the earlier year. My lords, my application dated 2nd December 19 was pending.
So for which?
For assessment year 15-16.
That is what I am saying. So that was the first application, or it was a repetition before the?
No, that was the second application, my lords.
So then the first one was rejected.
That's right, by the officer, but I went to the commissioner, my lords, against that rejection. My application before the principal commissioner was pending disposal when he did it.
And the next limb of argument by you is that all this explanation of consideration of your representation and then the AO communicating an order and then the adjustment on 23rd April is actually a later development because on 30th March itself it stood adjusted.
Absolutely, absolutely.
So what you say, and this is to put to the respondents, why have you not bring those orders, or perhaps you have brought it later on? Yes. To some rejoinder, you have brought those two screenshots of 19th April and 23rd on record.
Yes, Your Lordship.
By a later rejoinder or something, you have brought the screenshots of the portals containing the order of 19th April and 23rd.
Yes, Your Lordship. On 19th April.
But it's your categorical admission that intimation or whatever was that document of showing adjustment on 30th March
21
was incorrect.
Yes, Your Lordship. And that was mailed only on 19th, not before that. Although the intimation was of 30th March 2021, but mailed on 19th April 2021, and the adjustment was done on 24th of April. That can also be verified from NSDL portal itself. However, I have also annexed the screenshot and the challans through which it was adjusted, evidencing that and supporting my argument, Your Lordship.
Anyway, you can build up.
Yes, ma'am. My lord will just first, therefore, see, my lord's page 58. Page 58 is my return, acknowledgement for assessment year 2021. My lords, as per the return, there is a refund due to me of about 237863,180, which is item number 8. Right?
Yes.
Now, then at page 59, on 31st of March 2021, I get an intimation from the Central Processing Cell at Bangalore. Now, just see that mail at the top of page 59. It's sent on 31st March 2021 and says, your refund is proposed to be adjusted against an outstanding demand. Kindly respond under intimation under section 245.
Yes.
And what do they propose to adjust it against? You know, we'll just see at the back of page 16. Kindly note, your return has been processed at CPC and the same has resulted in a refund. The refund so determined is proposed to be adjusted against the outstanding demand table below, and he refers to assessment year 16-17 year. Then I may take you straight to page 63 also. Notes, I filed my response on 14th April and I say that I disagree with the demand. But let me just show you the annexure 4 at page 65 on 19th April. This is when they send me the intimation for assessment year 2021, computing the refund. Now we'll see the heading is your ITR intimation dated 19th April 2021.
Yes.
Now if my lord will just turn to page 77. It has a heading, you have a refund for assessment year 2021. Has my lord got that?
Yes, yes.
And just below that, you will find the intimation order date dated 30th March 2021.
Yes.
Right? And here you will see he determines the refund. The last item, item number 5, my claim was 23.78 crores. He determines it at 22.85 crores.
Yes.
And then please see page 82. The refund note 1. The refund determined is adjusted. It was not proposed to be adjusted, is adjusted against the outstanding demand. As mentioned in the table, details of adjustment of refund against outstanding demand and interest payable under section 222 given below. In cases where the refund adjusted is against demand which is other than CPC demand, you may consider contacting your current jurisdictional officer for any rectification or modification of such demand. And my lord will see he is adjusted it against demands for 15-16, 14-15 and 16-17.
This is of which date?
This is all dated 30th March 20. Manoj will see the intimation at page 77. The date is 30th March 2021. My lord saw that.
Yes, yes.
This is part of that intimation. And it clearly says is adjusted.
Yes.
Then, my lords, I can just point out to my lords page 114. Page 114 is the assessment order of 1617.
Yes.
Lords, this order is dated, my lord will see, from item number 14, dated 30th March 2021.
Yes.
Where it determines a total income of, at page 116, 101.84 crores. And the notice of demand which comes along with it is at page 123.
Same date.
That's right. It's dated 30th March. And it says, my lords will read para 1 and 2 of that notice.
Page 123. Yes.
This is to give you notice that for the assessment year 16-17, a sum of rupees 1241, details of which are given on the reverse, has been determined to be payable by you. The amount should be paid to the manager authorized by State Bank within 30 days of the date of service of this notice. So I have 30, as per their own showing, I have 30 days to make the payment. It is my case, they adjusted on 30th March itself. As per the revenues case also, they have adjusted on 19th April, 23rd April, which is within 30 days.
Yes. In the intimation at annexure 2 of 31st March,
yes, my lord,
did they indicate the relevant FY or only 2016-17 assessment year they indicated?
They, in that one, they said 16-17 only.
Only.
But in the on the intimation of 30th March, they've adjusted it against 3 years. 14-15, 15-16, 16-17.
Yes. Ms. Amrita,
Yes, Your Lordship.
apparently, as per the mandate of law, things do not appear to have been done. And papers are speaking for themselves.
Can I just show Your
Now,
Lordship? Thanks.
no, we can hear you, whatever is your answer, short answer or long answer. But intimation, you have heard the arguments and whatever we had also summarized at the outset. Next to the date on which adjust is shown. 1 year, there is a stay, 20% amount already deposited, 14-15. 15-16, there is no intimation on 31st March. 17-18, the assessment is of 30th March, so he gets 30 days to pay that amount. Before that, how can you presume that he will not pay and you will adjust against refunds? So the whole purpose of 245 seems to have been given a bypass. Now, we will hear you what you have to defend itself, but if you are convinced at your end that it is erroneous, then you can rectify your error.
No, Your Lordship, I differ from this particular because I can even from the facts I can show the things how it has happened and intimations were duly served for all the years, and that also I will show you from the record itself, Your Lordship. And there was no stay year wise year. I will be showing how the things has went down, and there was no actually any stay for any of the years. That I will be showing from the record itself, Your Lordship.
Do you mean to say that for the other 2 years, 14, 15, 15, 16, the intimation was given earlier?
What happened, Your Lordship? If Your Lordship may kindly turn to page 59, that is annexure to intimation under section 245. That is there. It just says that your refund is proposed to be adjusted again and outstanding demands. The next page, page 60, only indicates of 2016. There are two fold of this particular intimation itself, Your Lordship. The first fold is that here it says your return has been processed at CPC and the same has resulted in a refund. The refund so determined is proposed to be adjusted against the outstanding demands as shown in the outstanding demand table below. And the demand table below shows of 2016-17. Now, if your lordship may, and the amount is important, your lordship. The outstanding demand is shows as 12 crore 41 lakh 45,840. However, during this period, adjustment was done only of 4 crore and odd, your lordship. 4 crore and odd, the adjustment was done. The entire amount for this particular period was not adjusted for the reason the refund was not to that level, to not that extent, your lordship. And now the next page may kindly be turned around, page number 61. Here, your lordship, it says that there is a table drawn over there in page 61. It says that the outstanding demand as on that date, so any outstanding demand of earlier years will also be adjusted. It says that the outstanding demand as on that date will be considered for adjustment against your refund. So this particular is for the fresh of 2016-17, and so far as 14-15 and 15-16 is concerned, already intimation under section 245 was given, and therefore it has not been specifically stated in this particular intimation, and it has been only stated that the earlier demand, whatever is standing, that will be also adjusted. So if from the record itself, your lordship, the amount was indicated 12 crore. However, adjustment was done only 4 crore.
Intimation is to be in such a vague manner that the SSC doesn't know as to which year's demand you are going to adjust, so that he can give a response to that. The minimum that is stipulated under 245 is an intimation, so that the SSC can reply to that. And then its response will be considered by the AO, and if it is found to be in order, accepted. If it is not in order, or there is some the request is not as per law, then the adjustment will be made. If you do not indicate for which assessment year or which demand you are going to adjust it, how will he give a response to that?
They were duly under the knowledge, your lordship. My counter may kindly be seen page 27, and even various letters I will be showing one by one, as they were duly under intimation that a refund for the earlier year, that is 14-15 and 15-16 were outstanding, and we have duly intimated them that is outstanding and that will be adjusted against any refund arise thereof. Page 27 may kindly be seen. Before turning to page 27, your lordship, from the writ petition itself, I'll be showing certain documents. Page 194 may kindly be turned off the writ petition.
$190.
194.
Yes.
This is of 2000 assessment year indicated therein of 2014-15, and this subject is stay of recovery proceeding against the outstanding demand for assessment year 14-15. Now the last para may kindly be seen, the second para. The stay was not for indefinite period. There was a definite period till that the stay was there for the year 14-15. It says also it is being informed to the SSC that any refund arises for any assessment year will be adjusted against the outstanding demand as per section 245 of the Income Tax Act 1961. It is also being informed to the SSC that the stay of recovery proceeding has been given till 30th June 2020 or disposal of appeal at the first appellate authority, whichever is earlier. This case will again be reviewed after 30th June 2020. This is dated 8th of May 2020. Now the next page may also be turned and looked into, your lordship. Sorry, page 196.
You can come to page 197.
196 and 197 again I will be coming. That was again extended till 31st of December 2020. And here again it was written that any refund after 31st December, any amount is outstanding, because the stay was only till 31st of December 2020. So thereafter, if any refund arises, that will be again adjusted for this particular year. Page 96, last para may kindly be seen, your lordship, again. So this intimation was again given on 16/11/2020. This is dated. May I just read it, your lordship?
Yes.
It is being informed to the SSC that any refund arising for other assessment years will be adjusted against the outstanding demand as per section 245 of the Income Tax Act 1961. It is also being informed to the SSC that stay of recovery proceeding has been given till 31st December 2020 or disposal of appeal at the first appellate authority, whichever is earlier. The case will again be reviewed after 31st/12/2020. After 31st/12/2020, there was no extension of stay. So they were duly intimated about it, and to that extent, but again 240 was specific notification, a specific intimation was again sent to them. It was there with their knowledge, Your Lordship. It is nothing that it was not known to them. Stay was there for till a particular date.
Does it is it not covered by the suo motu orders?
Supreme Court order. Whether the stay was protected
That stay of recovery was not stayed, Your Lordship. The proceeding was stayed. Recovery was not stayed. The adjustment, the recoveries were not stayed. The proceeding was itself stayed. The notices issuance of these was stayed, but the recovery was not. It is actually not a recovery, Your Lordship. It is just an adjustment. This is not actually a recovery.
We are not on that. We are on the extension of the stay because of the general order passed by the apex court in the suo motu matter. You have the copy of those orders?
Yes, Your Lordship, I do have that copies. That was with respect to tribunals, with respect to courts, and with respect to other proceeding, but not with respect to the departmental specific notification was not there, Your Lordship.
not to be with the adjustment part. The board has informed that the chasing officer are not in any uniform procedure in this regard, while none such as in the Ministry of Law for years.
CPC is basically all computer based, Your Lordship, all system based. Nothing manually is done over there. And once they have been intimated about it that our outstanding is there, it is always being reflected, and the moment it is being paid or adjusted, it gets reduced accordingly. So older demand will be adjusted first, and then the recent demands will be adjusted accordingly. And for that reason, only 16-17, the entire demand has not been adjusted. Only 4 crore has been, to the extent how, after adjusting the earlier demands, whatever remained, that was only adjusted. Still 7 crore and odd demand is still there for the period 16-17, standing against the petitioner. And there is no stay so far as my knowledge is concerned. Although they have filed an application for stay, but there is no stay till date.
Have you rejected that stay petition?
Your Lordship, I don't have the instruction. 27 April it was filed. I particularly don't have that instruction. That was 27/4. That was after adjustment. They filed a stay petition. And Exhibit B to the rejoinder also contains certain intimations, Your Lordship.
Yes.
It's page 27 of my counter.
Yes.
The counter is filed by respondent number 4.
Yes.
Although it was for the refund of 2003-4, wherein in the year 2003-4 again certain refund was there, and that refund was adjusted with respect, certain portion were adjusted with respect to 2014-15, 15-16. First it was page 29. It was adjusted with the remaining amount of outstanding which was there for the period 2009-10. Later on, the entire outstanding demand has been shown at page 29. That is 25 crore and odd. For the period 2014-15 and 2015-16, the total demand was shown as 2 crore and odd, and that was accordingly adjusted. For the refund of 2003-4, part of the amount was adjusted, not the entire, and the rest of the amount has been adjusted in this particular period or the subsequent. So continuously they were being intimated about the outstanding dues.
This annexure D series.
D series.
Yes, is adjustment of the refund amount of 2002, 2003, 4 against certain demands outstanding for 2009, 14, 15, 15, 16.
Yes, Your Lordship.
The present dispute is about adjustment of the refund due for 2021 against 2014, 15, 15, 16, 17, 18. For that, your intimation is of 31st March 21.
Only for the period 16-17, and therein it has been indicated for the earlier periods also if any outstanding is there as on date.
So, you, in your notices of Annexure D series, you very correctly and properly describe in your intimation the years against which it is to be adjusted. In the impugn notice or in the notice of 31st March, you simply say for 16-17 and any other outstanding.
Because it was already intimated, Your Lordship, to them that the demand is outstanding for that purpose only.
How do you say that it was intimated?
So I have shown various letters, Your Lordship, just now, page 194, page 196, these letters. So they were under the intimation that the amount is due and they have not preferred for further stay on those matters.
And page 197, 198 are orders basically extension of stay, and the usual order that it will be adjusted under 245, but that is not an intimation under 245, that's an extension of stay till the pendency of the appeal. Do you treat it as an intimation under 245 like you that is there under, say, Annexure B series or D series?
There is no specific format of intimation, Your Lordship, of 245. It was just to intimate. The section itself also says that to intimate about the refund, if any.
So intimation, you do it in different formats at different point of time. You say that a standing instruction has been framed pursuant to the Delhi High Court's order in suo motu writ petition. Now you are using different formats that those series 196 to 198, 199, you are saying that's also an intimation.
That is the...
There is no demand mentioned, there is no refund amount mentioned, and you treat it as an intimation.
Annexure B again, Your Lordship. Yes, that was for the period 2002-3.
So there is the edge or whatever is the lacuna which we are stuck at. Computer hasn't applied its artificial intelligence properly.
What happens, Your Lordship, once any kind of intimation under section 244 is given, because there is nothing manually. Everything is self-system feeded and self-feeded. And then again for the same period, the notices are not being set. It is being just treated as the notice has been served for a particular period and that is sufficient. Re-intimation again and again is not being done. This is what I have been instructed for, Your Lordship. And to that extent also, I have made a statement in my counter affidavit also upon their instruction itself. So this is the fact, Your Lordship, which is there. So that the system doesn't so that again and again they have to intimate for those particular period wherein one intimation has been given for those particular period itself. And they cannot do that. Actually, they cannot do that. This is what has been instructed to me, that they cannot do it manually because it has all been just, they have to click a button and nothing else. It's not in their hand at all.
It is the same argument as regards the GST portal also.
Yes, Your Lordship, that is.
State tax authority saying that since summary of the show cause notice is in a format under DRC 07, therefore they cannot insert anything or add anything beyond that.
Although the system has been made computerized, but things have not been properly done, Your Lordship.
So the requirement of law doesn't get achieved if that kind of computer-based compliances or notices are issued. computer has mistook it, they have adjusted. The computer had adjusted it before actually an intimation was issued also.
Yes.
No, Your Lordship, it was not adjusted. I have annexed that particular thing also, Your Lordship. That page, my second supplementary affidavit may kindly be seen, Your Lordship. The particular format is the particular screenshot is there itself, Your Lordship, and that can also be, I am repeatedly saying that can also be verified by the petitioner itself from the NSDL portal, that when it was in the earlier period, the petitioner itself has stated that they have verified from NSDL portal. Even in this case, they can do so, Your Lordship. That also have been stated, and I have also annexed page 9, annexure R3, the screenshot, the computer screenshot, wherein it has been specifically shown that when it has been adjusted. Merely by writing it has been adjusted in the intimation. However, intimation also says that you have a refund for a period. There is a line, Your Lordship, that it is adjusted, but actually it has not been done. When the act is done, that is important, Your Lordship. I have also
There is no intimation for.
it will reduce. Sorry?
There is no intimation for 2014, 15 and 15, 16.
I will again say, Your Lordship, that intimation was there subject to Your Lordship.
No, your own B series and D series show that every time you intimate it in a proper format. This time you have already referred to 16, 17 and left out 14, 15, 15, 16. I don't know what kind, Mr. Pardiwala, your response of 14th or 13th April was for all the 3 years or for 17?
Only 1 year, my lord.
Only 1 year because he understood.
Because I had got intimation only for, and my lords, as my lord rightly said, my learned friend referred to page 196, 198. But look at page 27, which she relies upon in her counter affidavit.
That we are already pointing out to.
Yes, my lord. It says intimation under 245 for 14, 15, 15, 16.
That is what we have pointed.
Yes, my lord. My lord correctly pointed out that for assessment, when you adjust the refund for 2-3 against the demand for 14, 15, 15, 16, you correctly give intimation, though that letter of stay extension refers to the fact that you reserve your right. And my lords, that is brought out. If my lord will just see the circular issued by the board, my lord, please see my petition itself at page 199.
Is that 1996 circular?
Yes, my lord. No, 2016 circular.
The 2016. Yes.
Now, also just see Roman 3 of para 4 at page 200. They reserve the right to adjust refunds arising, if any, against the demand to the extent of the amount required for granting stay and subject to the provisions of 245. So even their board circular says that you cannot do away with 245.
So 20% is the amount for granting stay.
That's right. Minimum, well, that is automatic. You can ask for minimum or you can, in an exceptional case, say even more should be done. But the normal rule is 20%. So, Manoj, the point here is what I was just trying to indicate is that the law mandates that you have to give an intimation. Their own circular says you have to give an intimation. They, by their action for 2002-3, say that yes, we have to give an intimation. You can't rely upon the statement in the order extending stay to say that now no intimation is required to be given. And my lord asked, what has happened to my stay application? My stay application for 16-17 is still pending. It's not yet disposed of.
Still pending before?
Before the assessing officer. Because I filed it on 27th April of last year, still pending disposal.
That is after adjustment, filed after adjustment.
No doubt about it. Just take it. Ask him. Hello? One second. 960.
Yes, Mr. Lambar,
Malaj.
you are in the second matter.
Malaj, I'm in the second matter. Malaj, there are twofold arguments of the petitioner, Malaj. The first fold of the argument is that by way of an stay order, the demand of 1415 could not have been adjusted. This is their first limb, Malaj. The second limb of argument is
First limb is the first one, that without intimation, no adjustment.
Malaj, yes, that is there, Malaj. I'm on the other limb, Malaj. Another limb is that because there was a stay order, 1415 could not have been recovered. So, Malaj, kindly let's see what is the stay order. Malaj, may kindly have page 60 of this.
We are on the legal issue about the intimation, proper compliance of 245.
Malaj, I totally agree, Malaj. I bow down. Let me be very fair, Malaj, that there appears to be an irregularity, but the question is that is there any specified format in law which the department has not followed? Malaj, in substance, department had given prior intimations time and again that 1415 demand will be adjusted against refunds. But the question, Malaj, the issue remains whether
there is a purpose for giving intimation. Okay.
Malaj.
That is governed by principle of natural justice. See, I want to take 2 crore from your refund, and there are facts that you have sent intimation, and adjusted on the second day or third day.
Malad, not in my case, Malad. In my case,
Maybe. So I want to say you seek instruction from your to rectify.
I agree. I don't know.
To rectify, you discuss with assessing officers to rectify
bow down.
to computer faceless. I mean, there are some problems faced by the assessing officers also. What could be done? Because admittedly, as per the record, 245 has not been complied with. In true letter.
Malad, that is what, my lords. If my lords think fit and if my lords can give us the liberty, we will comply with 245 and then proceed. Malad, I'll take specific instructions on that, Malad.
Yes.
I'll take specific instructions.
Both of you seek a specific instruction in the background of the facts.
Malad.
We will be, Your Lordship.
Malad, in that view of the matter, then my lords will have to frame a view that under 245 that specified format of intimation has to be there. Our line of
your own format is
I know, Malad. I know.
number 4.
I know, Malad. I know.
We asked respondent number 4 because that is the place where all these things happen. They themselves have enclosed the letter of intimation. So
I agree, Malad. My department cannot have different practices for different years. I agree, Malad. I appreciate, Malad. I appreciate. That is a problem, Malad. But this is an irregularity. That is what I'll argue, Malad. This is an irregularity.
Irregularity hits an assessee or an individual person at which place, what pinches, that the assessee can only imagine.
You cannot equate an assessee who is a salary class, business class, whose turnover is more than crores.
I appreciate, Malad.
Talk huge crores of rupees. You can well understand this fact.
I totally appreciate, Malad. I bow down, Malad. I'll take instructions from my client. Malad, there is no point further lingering this matter. I'll take instruction.
We'll keep it on 8th March.
Fine, Malad.
Mr. Padiwala.
Yes, my lord. 8th March is fine. No, it will be virtual or physical, my lord?
Things are always fluid, so
very well. Very well. We'll take our chances, my lord.
We have heard, we have heard the senior counsel for the petitioner, Mr. Percy Padiwala, assisted by Mr. Sumit Garodia, and Ms. Amrita Sinha and Mr. Rahul Lamba in the respective writ petitions appearing for revenue stop. During course of submission, certain legal issues have cropped up from the pleadings on record on which learned counsel for the revenue prays for short time to seek instructions. Stop. Let the matter appear. Today is 21st. 8th March 2022.
Much obliged.
Yes, my one passover matter is there 5 serial change. It will be taken up after lunch or passover.
Just we'll call your matter. Let us see.
Item number 8.
Item 10.
Item 10.
File में है
State is the petitioner in this case. I am for the
इसमें हाँ नहीं एक ये भी था 24 में मिस्टर सचिन.
Yes, he is. Yes, I am here.
In item 24, what do you propose to do in the legal position?
Milord,
in my above submission, my lord, perhaps in this case, my lord, the procedure has been followed. So, 73 notice was issued, my lord, 73-1 at the relevant time, my lord, 01A was not there. So, 73-1 was issued, opportunity was granted. So, they can prefer appeal, my lord, and challenge the order if they are agreed.
No, where is that 73-1 notice? Annexure 5.
Yes, minutes. Annexure 5.
So, adjudication has taken place pursuant to Annexure 5.
No, minutes. Never.
Yeah.
Never.
So, Annexure 4 is summary and Annexure 5 is the SCN, and the SCN is hit by the same reasons for which we have decided two other matters, one under 74 and one under 73.
My lord.
The earlier period, in respect of 73, we had given Mr. Pati time to seek instruction as to whether they will rectify. He said that Lordship may pass order this time. I have instructed them to rectify. Now again the same situation is coming up in this repetition. How many times we will...
These are old matters, my lord, same period. You also will find 2020.
2018-19. 3 years from 18-19 becomes?
Minutes 2022. The time is still there, minutes.
2022.
Yes, minutes.
So time for issuing notices up to 31st March 22 or...
If I refer to 74, section 74, 74(9). I'm sorry, no, so 74(10). 74(10). It is 5 years, minutes.
No, this is under 73, section 73.
This 3 years from the due date of furnishing annual return, which has been extended, minutes. So they have time, minutes.
What was the extended time limit for submitting returns for this particular period?
Minutes 18-19, it was extended up till minutes April 2020.
Then
so 3 years from there, minutes.
20 April, that is 31st March 2023.
Correct, minutes. So it will go up to 31st March 2023, minutes.
Mr. Sachin, that is the position as it stands.
My lord.
And Annexure 5 is not a proper show cause notice. So we give you one time to seek instruction and they can withdraw it and issue fresh notice.
That will be the next week, Lord, I will seek instruction in the meantime.
One more thing, minutes.
Yes.
One more thing, minutes. The electronic credit ledger which has been blocked in 2020, that aspect also needs to be dealt with by them because there is an outer limit prescribed.
1 year.
Yes,
actually, my lord, what has happened? They have utilized, my lord, the input tax credit, my lord, beyond the limit, my lord. My lord, the balance available in the my lord, credit ledger was less, and they, my lord, got my lord, a set off for a higher amount of about
How can
more
it
than
be?
6
It cannot
lakh.
be possible. It cannot be
That is the
possible.
whole case. That is the whole case. So that to that extent, my lord, it has been held up by the department. If someone has wrongly held, though it was not available, if that is not...
my lords would allow me, I can point out, my lords, where is the discrepancy, my lords, subject to my lords permitting me.
In view of that judgment, you can issue a fresh show cause notice. And in that way of the matter, this writ application will become infructuous. Because development has taken place pursuant to that judgment.
We have taken a stand that balance available Milord in 2A was 10,55,000, and they have available Milord the credit of Milord 16,73,000.
That is because of the mismatch for which I replied, which was never taken into consideration. That is the whole case.
And one more issue, Milord, that they have against Milord challenged DRC 07, not the Milord the region order.
Where is the reasoned order? DRC 07 is, I have annexed it. If my learned friend says it's a reasoned order, page 35 minutes, may see. If this is a reasoned order, page 35, which is under challenge. Even after the judgment of this honorable court in NKS, if my learned friend says that this is a reasoned order, then I have nothing to argue beyond that.
I said, Milord, that he has not challenged Milord the region order. This is DRC 07.
Where is the reasoned order? You have not even annexed it. Never communicated.
Let it be in the next week, Milord. I will let me see instruction as your Lordship, Milord, directed.
General Counsel for the petitioner, Mr. Kesari, submits that the so-called notice at Annexure 5 is not as per law. As per the requirement of law under Section 73 of the JGST Act, he submits that similar issue has been decided by this court in WPT number 2444 of 2000.
21 minutes.
And what was the number of the other one?
2659 of 2021.
2659 of 2021. Stop. The notice is vague, is in a format. The notice is in a format, vague, and does not strike out the irrelevant particulars, nor the contraventions have been indicated, so that petitioner may furnish a proper reply thereto. Stop. No adjudication order has been communicated. Instead, the summary of the order under under GST DRC 01.
07 minutes.
07, next chapter
yes,
7, has been only intimated. Stop. Learned counsel for the respondent AG2 seeks short time to obtain instructions. Stop. List the case on next Wednesday.
Yes, minutes. Much of it.
Item number 10. WPS number 531 of 2018, Mr. Sandeep Kumar for this matter.
Lord, in this case, item number 10, Your Lordship, I am for the appellant, Your Lordship.
Yes.
As per the last one, Your Lordship, we have filed one affidavit, Your Lordship, that is dated 18/3/2021, Your Lordship.
Yes.
In which, Your Lordship, in paragraph 6, Your Lordship, in paragraph 5, we have quoted Rule 3 of 1997 regulation, Your Lordship. And thereafter, we at paragraph 6, Your Lordship, we stated that whole selection process came into end, Your Lordship.
We will admit this petition and hear it. Yes.
In this case, my lord, the legality of the order has been challenged. Therefore, that will be decided whether the informed order in which they have filed this case is tenable in the eye of law. And then only what relief I can get, because the two promotion has been given subject to result of the case of OA pending before the court. And in the contempt proceeding also, they are directed to implement that order. Before this honorable court, there is no stay so far the interim order is concerned. Only no courtship step can be is to be taken in between the period, that is for the contempt petition, because contempt was filed and time was granted. And even in a vacancy in the year 2016, subsequent vacancy 2017, 18, um, the case of the petitioner has not been considered. And the affidavit which has been given by the UPSC, my lord, that is very much clear that even in spite of their direction after the judgment that defer the date of the screening committee meeting, they have not fulfilled the matter. They have not responded anything before the UPSC and never consulted whether the post will be lost or not. Kindly see their affidavit, my lord, which has been filed in pursuance of your lordship's order 23-2. Even they pledge that this petition is fit to be dismissed. Kindly
So,
consider.
all the sides prepare their short notes because the brief has become factual details should be summarized. Brief has become bulky. And we will admit it and hear in very near future. After a short.
My lord, in the next week, my lord, that will be hard because the.
Next week.
Or it would be better, your lordship may fix in the physical hearing, your lordship.
No, when it will be done, I don't know because I have crossed the age for the further employment also, and all things is depend upon the case of this case. Fate of the case, petition, the respondent is dependent upon the decision of this case, and it has been heard so many times, my lord. I have given the written argument long back.
You prepare a short note, all of you, and give your decision on and the rule, position, regulation, etc. in your compilation, short compilation. We will keep it just after holy holidays. We will not admit it, but we will keep it in the second half of the day when we can hear it freely, peacefully.
My lord.
We'll keep it on 23rd March.
23rd.
23rd March.
Well, 20, not that week, my lord. In the next week, my lord.
29th March.
Yes.
29th March.
At 2:15 on the data, that may be disposed of on that day.
Yes.
Yes. Let it be.
On 23rd March, 29th March 2022 at 2:15 p.m. If not taken earlier. Stop. Learned counsel for the parties would submit their written notes, decisions, and rules/regulations on which they seek to rely, the provisions of law on which they seek to rely in a compilation to the court master by 15th of March 2022. No, 15th May. 21st of March 2022. At least 1 week before. Very well. Thank you, everybody.